We all have different ways to plan our estate. What type of plan is best for you and your family depends on what you'd like to accomplish. I'll be discussing today 7 different ways to plan your estate, beginning with the most popular ways and then talking about the more sophisticated ways that even have greater benefits for your family. Opportunity number 1 is the Jerry Brown special. That is, let the state of California plan your estate for you. This is called the intestate statute. Every state has some version of this intestate statute, but because you've been too busy with your family, too busy with your business, you've never planned your estate, the state of California has that plan for you. Your plan was written by the California legislature. This is the worst type of plan to have. Option number 2 is the do-it-yourself plan. California is one of 17 jurisdictions that allows you to plan your own estate. This is called a holographic plan. Holographic comes to us from Greek, meaning entirely written in your own handwriting. Chief Justice Warren Burger of the United States Supreme Court is an example of somebody who planned his own estate. A brilliant corporate attorney, but not at all knowledgeable in the area of estate planning. He planned his own estate and ended up in probate, which took several years, and ended up losing hundreds of thousands of dollars in federal estate taxes because he did not have a proper plan. He planned it himself. Option number 3 is what I call the I love you will. I love my spouse, I leave her everything I have. If she's not here, it goes down to our children equally. These first 3 arrangements are by far the most popular ways of planning your estate. The Jerry Brown intestate statute, the holographic will, or the I love you will. The next 4 arrangements take the form of different types of trusts, a concept we received from England that's been used in England for the last 800 years to keep people out of court, to save time, to save money, and to achieve privacy. The testamentary type of trust is a type of trust that's created in your last will and testament, and it literally springs up out of your last will and testament at the time of your passing. The testamentary trust is a better way to plan your estate than the first 3 because it can save taxes, but it forces you into probate in order to achieve that tax savings. Another option you'd have would be the revocable living trust. Revocable meaning you change it during your lifetime. Living meaning you set it up while you're alive. The revocable living trust can be set up for somebody who's single as well as somebody who is married. If you have a $1 million home and if you're single, the revocable living trust can save approximately $50,000 in probate fees and save at least a year delay for getting the assets down to your children. Another option you have is called the AB trust or the ABC trust. This comes under different names. It's sometimes called the marital deduction trust or the credit chiller trust. This will save you probate fees, conservatorship fees, and also save taxes. Today it can save between $300,000 to $600,000 in federal estate taxes. It protects the husband and wife and then passes the assets on down to the children, usually at staggered ages. After the husband and wife die, the children often receive maybe 1/3 at 25, half at 30, and the balance at 35. The final option is what I call the triple generation trust. It's also called the dynasty trust or the legacy trust. In my opinion, this is the biggest legal loophole there is in the tax law. It's an opportunity you have to enhance the inheritance going down to your children because you can avoid predators and creditors and gigolos and floozies, not just for yourselves, but also for your children, grandchildren, and great-grandchildren. This triple generation trust will eliminate the death tax for your children, grandchildren, and great-grandchildren. It can avoid creditors and predators for your children, grandchildren, and great-grandchildren. It can make sure that your family money continues in your family trust for their benefit for generation after generation, and avoid the in-laws who sometimes become the outlaws. So in a nutshell, there's 7 different ways we can plan our estate. We know the most popular ways of planning your estate, the first 3, the Jerry Brown intestate statute, holographic do-it-yourself will and the I love you will require a probate, will force you to pay unnecessary federal estate taxes, may also subject you to a living probate known as the conservatorship. The next four arrangements, the testamentary trust, the simple revocable living trust, the AB or ABC trust, and the triple generation trust, these are opportunities to do a better job of protecting your family and protecting your assets. My name is W. Bailey Smith. I'm certified as a specialist in estate tax planning by the California Bar. I have 40 years of experience. I'm an attorney at Treadway, Lumsden, and Doyle. I'm delighted to meet with you on a courtesy basis to review your current plan. Thank you.